judgment has been overruled?
No.
High Court? No.
All the judgments, relevant judgments.
You have also annexed the SLP order of Chhattisgarh High Court.
I did not find. I'll find it tomorrow. I'll bring it back.
Yes, that has been, I think, upheld.
That has been upheld. That is an edited position. But I'll find out the order also.
Passover case from Delhi list item 34, Kinder Division 218 of 2019.
Both the learned courts, Your Lordship, have gone wrong on a very basic point. That is, 15 days from the date of receipt of the notice. That is a mandatory provision of law. Please allow me only to point out section 138C. As far as 420 is concerned, Your Lordship, it is the case of the complainant himself that on 3 dates he had given rupees 1 lakh and something, total 4,85,000 on 4 dates, Your Lordship. 1 lakh amount, 1 lakh, 1 lakh, 1 lakh. Subsequent to that, on every date he used to say that come and get the land registered. Finally, when it was not registered, Your Lordship, then it is stated that when they went to their house, he brought a check from the top story and gave it to him, which contained 4,85,000 to be given. Subsequent to that, he gave it for honoring that check in his account, and the check which was given was of Calcutta branch, Your Lordship. And thereafter it was stated that as because the check was of a closed account, the money could not be given to him. It stood dishonest. The bank authorities informed the complainant that as the account is closed, so the money could not be given. Thereafter it is stated by Exhibit 4 that a notice was given to the present petitioner to make payment of 4,85,000 within 14 days, or else necessary action will be taken and a case will be filed. The only point which I am trying to harp upon as regards 420, Your Lordship, 420 is not made out because of the fact that had he any intention of cheating of that 4,85,000, Your Lordship, he would not give a check to the person that this is a check and it will be used as a evidence, knowing full well that the account is closed. And secondly, 138, Your Lordship, the mandatory provision of law. Please allow me only to point out 138C. That is mandatory. And that has not been done anywhere. On that score alone, Your Lordship, both the judgments pronounced by the learned courts are liable to be set aside. 138C, Your Lordship, specifically says the drawer of such check fails to make the payment of the said amount of money to the payee, or as the case may be, to the holder in due course of the check within 15 days of the receipt of the said notice. After he receives the notice and it is given within 15 days, if he does not repay the amount.
I think you have a old book. Do you have old book?
No, Your Lordship.
Which edition is this?
with effect from 1/9/2018.
There has been certain amendment, I think it is 1 month now.
1 month is there, your lordship, in that. The complaint has to be filed. That is,
That's it, 15 days for payment.
after the notice, within 15 days he has to pay. And if he does not pay, your lordship,
Then within 1 month.
within 1 month the complaint has to be filed.
That's right.
And if the complaint, that amendment, your lordship, is 59, it came with effect from 6/2/2003. Here in this case, your lordship, what has happened? Receipt of the notice has nowhere been taken into consideration, nor the complainant has said anything about it, nor both the learned courts have taken, nor there is a whisper as to on which date the notice was received by the present petitioner. And
Where is the opposite party?
actually, your lordship,
He was there in the first half.
in the first half, I was. And this is the only short point, your lordship, on which I will harp upon.
Have you got any judgment?
Yes, your lordship. This is a 3 judges bench judgment of the Honorable Supreme Court on and from paragraph 32 till 40. Only this matter has been discussed.
No other judgment you have brought?
Only to this point, it
There is
is.
a latest judgment and not less than one, I must say 30 judgments have been passed by me on this point. But you are not aware about our high courts.
No, your lordship. I will give those judgments.
No, not required. Not that. There is a recent judgment of Honorable Supreme Court in 2023 on the same point. But reserving the right to file a fresh complaint. That right has been reserved because it is premature complaint.
Your lordship, but then that delay condonation has to
Yes,
be there.
that is also there.
Because
That observation is also there.
Section 2D defines about complaint.
That observation is also there in the Supreme Court judgment. The Supreme Court has given 2 months time to file a fresh complaint by saying that it is a premature case.
This aspect has been decided in this. In this also it has been decided.
Yes, in this also it has been decided.
And this is a
And following this, I have passed numerous orders, and now we have a judgment of the Supreme Court also. That in a case of premature complaint, it can be filed with explanation of reason. Of course, that has to be taken care of. But where is the respondent? कैसे क्या करें?
No, actually I am at fault, your lordship, because your lordship had directed that it will be at 1 o'clock. On that date, I could not come, your lordship. Please just come to paragraph 32 and thereafter. Paragraph 32, your lordship, 5, Roman 5. These are the ingredients which are necessary, if I am permitted.
No, I have read it number of times with all responsibility at my end. I followed it, and I'll just show you.
No, this is the point of law, your lordship.
That
And
is
your
the point
lordships
of
have
law
already
because
read.
the timeline is required to be proved.
To be proved from the date of receipt of the notice.
Certainly.
In the present case, if I am only permitted.
What is the date of check?
You
You just give me 2 dates: date of check and the date of complaint.
Yes, your lordship. I have tried to make a short note giving all the dates also. Please just have a look. The last page, your lordship may please just have a look to the last page. The check allegedly given by the petitioner is on 9/7/2014. This is the date. Presentation of the check before the bank on 17/7/2014. Checks with certificate returned from Calcutta, your lordship, on 18/9/2014. Legal notice issued
Your
on.
complaint is premature. Legal notice is 27/9/2014. What is the date of receipt? And if we assume deemed service, then it will be 1 month, 30 days. Legal notice is 27/9 and complaint has been filed on 17/10. Not only deemed service plus 15 days and then 1 month. So that right to file a fresh complaint can be saved. But so far as 420 is concerned, what do you have to say?
Lordship, as per the one, I have got one judgment from the Kerala High Court, Your Lordship. I have several judgments. I have to kindly look to this judgment of the Honorable Kerala High Court, Your Lordship. Para 10 and 11, Your Lordship.
What does it say?
The same thing is, Lordship, the close account, the check was issued. The court has found section 420.
Made
and
up.
spent. Accordingly, that has been dealt in section para 10 and 11. There are several judgments of the Kerala High Court on the same issue, Lordship, but that's right.
You see, the finding in this case with regard to 420 is regarding his past conduct. Right? It is not merely because a person has issued a check of a closed account. The finding is recorded that at the time of taking money, he had the fraudulent intention because he had taken money to secure some work, some job.
Yes.
So here, therefore, I'm asking you, you see, the fraudulent intention should be there with regard to the original transaction.
So here in this case also it has been held that as because he knows about that the account has already been closed. So intention was there from that has been gathered by the
Intention means he had the intention not to dishonor the check. Simple. No, not to honor the check.
yes.
He had the intention not to honor the check.
And
That's it. Nothing more.
and also cheat the
No, therefore, his transaction earlier with regard to land transaction and the money, where is that finding that he never had the intention to transact
no,
transact in
that
the
finding
land?
has not been recorded.
That finding is not
That
there.
has not been recorded.
So, under such circumstances, 420, this is a different set of facts altogether. Suppose there are two situations. One is that there is a genuine transaction between the parties, and one says that I have gone bankrupt, I don't have money, but still he issues a check, right? And that check bounces. So that original transaction, which was a genuine transaction, if somebody faults in making payment, defaults in making payment, then they have a remedy under law. That is a civil dispute. But if the original transaction by itself is a fraudulent act, then only 420. That finding is not
That
there.
finding is not there. I must say neither in the appellate court or
Any anyways, I have to read this judgment. There are so many judgments referred also in this
Yes,
case. We will not ignore your judgment. Have you given him a copy?
yes, sir.
You place and then let me see how does he respond. SLP filed against this? Have you checked up?
Yes, sir. That has.
Can you place this judgment? Case was instituted only under 420?
420 also.
And 130.
138 also.
138 also?
Yes, sir.
Your Lordship. 420 and 130.
Can you look the page, last page also, page 16.
You just see the first page.
Yes.
First page. Para number 2. The facts.
That case is that for providing a job, they have taken a money.
So
That
case
is the
was
case.
instituted. The case was sent for investigation by police.
136 years.
Right, and then the cognizance was taken under which section? It is, I think, only under 420. The case was only under 420. The case was only under 420. Yes, Mr. Tiwari, the case,
Our case, Your Lordship, is under
both.
420 and 138. And it is a complaint. FIR can be lodged under section 420, but in a complaint, Your Lordship, the cause of action arises after 15 days of the receipt of notice if he does not.
No, that's right,
pay.
there is no doubt on that.
Only
That he also agrees, but his right will stand protected. We are on 420, whether 420 has to be retained or it has to be quashed.
Yes, Your Lordship. There was no question of any 420 because of the fact, Your Lordship, that to reimburse 485, he had given a check.
From a closed account. This is
Uh,
what he is saying,
yes,
that
on
the
a
Kerala
closed-
High Court holds that if you issue a check knowing well that this check is not going to be encashed, that amounts to 420.
Then, Your Lordship, that judgment which I had earlier placed, Your Lordship, that both for that case, Your Lordship, 420 and 138, although in different
That
cases.
is different case, Your Lordship. That the two separate cases have been issued at double jeopardy. That issue
Yes,
is
yes,
different.
that we have
is-
seen. The
that
separate
issue
cases is
different.
different thing.
That is totally different issue.
Where is the complaint?
Your Lordship may please.
Just a minute. Mr. Tiwari, you have given your written submissions. Do you have anything else to say on this?
420,
Kindly elaborate on 420.
420, your lordship, is not made out. Please just have a look too. His solemn affirmation.
Yes.
Your lordship, may please just have a look to his solemn affirmation.
PW1? No.
And PW4. His PW4, your lordship. But in the complaint, the solemn affirmation is given. Essay. That is the basis of the complaint. Has your lordship got
Just.
Back page of the first,
back page of the complaint?
back page of the
Yes,
first
yes,
page.
I'm just seeing that. Yes. Kudus Ansari.
कुदूस अंसारी। यह मुकदमा मैंने शत्रुघ्न चिरनिया पर किया है। शत्रुघ्न चिरनिया से उसकी पत्नी की जमीन खरीदने की बात है।
आप थोड़ा मुझे हेल्प करेंगे जरा, बस निकालिए प्लीज से निकालिए। Yes, please. पढ़िए।
यह मुकदमा मैंने शत्रुघ्न चिरनिया पर किया है। शत्रुघ्न चिरनिया से उसकी पत्नी की जमीन खरीदने की बात हुई। 5 कट्ठा जमीन 1,01,000 प्रति कट्ठे के दर से 15 जनवरी 2014 को बात हुई। जमीन के एवज में 1/2/2014 को 1.5 लाख, 1/3/2014 को 1.5 लाख और 1/4/2014 को 1,85,000 दिया। 20,000 रुपया बकाया रहा, जो कि रजिस्ट्री के समय 7/4/2014 को देने की बात हुई। पैसा शत्रुघ्न चिरनिया को पूजा चिरनिया, इंतकाब आलम और मोहम्मद हुसैन वो शंकर मंडल के समक्ष दिया। शत्रुघ्न चिरनिया ने जमीन रजिस्ट्री नहीं किया तय दिन पर, फिर कहने पर टाल मटोल किया और बाद में पैसा वापस करने की बात पर डेटेड 9/7/2014 को 4,85,000 का चेक नंबर सच एंड सच ABN एमरो बैंक कोलकाता का दिया। वो चेक मैंने SBI लाल मट्टी के अपने अकाउंट में जमा किया, पर चेक एनकैश नहीं हुआ, क्योंकि जिस खाता का चेक दिया था वो खाता बंद हो चुका था। इस बात की सूचना मैंने वकालतन नोटिस के माध्यम से दिया, जिसका शत्रुघ्न चिरनिया ने कोई जवाब नहीं दिया। तब मैंने यह केस किया है। बाय कोर्ट मुकदमा शत्रुघ्न चिरनिया पर किया हूँ। जमीन पूजा चिरनिया का खरीदने का बात हुआ था। कासिम बाजार राजमहल जामावंदी 90/32 प्लॉट नंबर 329-330 का जमीन खरीदने की बात हुई थी। सारी बातचीत लिखित मौखिक रूप में हुई और मौखिक इकरार हुआ था। बयाना नामा नहीं बनाया था। जितना भी पैसा मैंने शत्रुघ्न चिरनिया को दिया, उस किसी रकम का पावती नहीं लिया। पिताजी जमीन बेचकर पैसा दिए थे, सारा पैसा नकदी के रूप में दिया था, बैंक से पैसा नहीं निकला।
सरद यादव को 1 बीघा।
शरद यादव को 1 बीघा 8 कट्ठा 2 लाख बीघा के दर से बेचा। These are the questions, Your Lordship. None of the persons have been cited as a witness. His father never came. And besides that, the main point for Your Lordship's kind consideration would be that 4,85,000, which according to him he had given, Your Lordship, that was for purchase of a land of the running in the name of the wife of the present petitioner. And subsequent to that, on the date on which the registration was to be done, Your Lordship, he did not come to the registry office. Thereafter, it could not be registered, and subsequently he gave a check of that amount which was dishonored because the account was closed. My humble submission before Your Lordship is there was no intention of any cheating because of the fact, Your Lordship, that he had given a check to reimburse the amount that he had taken. If there was any intention of cheating, Your Lordship, there was no question of giving the check to him. And still I say, Your Lordship, 420 and 138 cannot run together. 138 is a special act, special laws complete, they are already there. In a special law, Your Lordship, the general law will not apply.
ये तो नहीं चलेगा। 420 लग सकता है, ingredient है कि नहीं बात है?
No ingredient
That is
of
a
cheating. That I have stated, Your Lordship, there is no ingredient. Now, Your Lordship, he has made this statement on the basis of which the entire
In the complaint, have you made any such allegation that he had
intention of
fraudulent
cheating
intention of
at the
cheating
beginning.
at the time of taking the money? Because 415 clearly says that you have to fraudulently take the money from other side.
Your Lordship, that averment has not been.
That
cited in the
averment is not
complaint.
there in the complaint,
Yes,
even
sir.
in the solemn affirmation that is not there.
and even in the statement made before the court.
But Your Lordship, the conduct of the
No,
petitioner.
conduct we will see.
Conduct of the petitioner, because it has been clearly stated in the essay that.
You just see ingredient of 415. Read 415 हमको किताब दीजिए भाई. आप जो judgment दिए उसमें quoted है केरला.
Yes, sir.
Read it please. Page number 5, internal page 5.
Yes.
Whoever by deceiving a person fraudulently or dishonestly induces the person so deceived to deliver any property. ये ingredient कहाँ है आपका केस?
As per Your Lordship, that as per the ingredients of deceive, with regard to the question of deceive, Lordship, they have stated that they have sold the land in favor of the complainant, but on the date which has been fixed by the party to register the deed, on that day they
So
have not come and
therefore-
refused.
so therefore-
that has come in the
So
essay.
therefore, it's a case of specific performance of contract. At best, there are two things. There is a land deal and the person does not ultimately agree for transfer of property, right?
Yes,
Normally, these kind of transactions are required to be put in writing, and it is now compulsorily registrable also. Agreement to sale is compulsorily
Yes,
registrable.
yes. But again, that Your Lordship, they have again issued a check.
Oh, therefore,
Yeah.
so therefore, your specific case is that the ingredient of 420 creeps in when they issue a check.
Check on of a closer account. Of a closer account. That is the
So,
specific.
what is the act of issuance of a check? Act of issuance of a check is refund of money, isn't it?
Yes, Your Lordship. Refund of money.
Refund of money. In a case of refund of money by issuance of check, which is not preceded by any ingredient of 420 prior to that, right? The money originally was not taken fraudulently,
Yes.
but at the time of return of check, he never had the intention to return, right? So show me from 415 that such a kind of situation would be covered by 415. You read it. हो सकता है कोई स्टेटमेंट आपका फेवर में आ जाए. पढ़िए 415 पूरा ही पढ़िए.
Yes, sir. Cheating, whoever or by deceiving any person fraudulently or dishonestly induces the person so deceived or deliver any property to any person or to consent that any person shall retain any property or intentionally induces the person so deceived to do or omit to do anything which he could not do or omit if were not so deceived, and which act or omission causes or is likely to cause damage or harm to that person in body, mind, reputation or property is said to cheat.
Now tell us the act of issuance of a check to return an amount, will it come under cheating?
Your Lordship, on the conduct of the
We are not. We will go absolutely by the ingredient, because prior to issuance of check there is no element of cheating.
yes, sir, that is that.
So
that
you are imputing element of cheating at the time of issuance of check by stating that he has issued the check from a closed account.
closing.
So you tell us the act of return of check, act of return of money by a check, right?
Yes, sir. And because they have, the petitioner has known this fact that the account has already been closed.
Therefore, act of return of money by check, does it come under 415?
That's what the Kerala High Court
So
has.
it's not binding on us.
Yes,
What do you
that-
think?
that-
We
I have never-
can't
I have
distinguish
never-
that judgment.
I have never said you.
It is not binding on us.
I
So
have
there
not-
should be contrary views of different high courts.
I have never said that.
So that there should
that
be.
is there. That is there.
We are not bound by Kerala High Court.
I am just citing a judgment for your consideration
We
of this honorable
cannot.
court.
You see, if the ingredient of 420 is not there prior to issuance of check, if the
That-
ingredient
that-
of 420
that-
is there in prior to issuance of check, there is no problem, because issuance of check is a continuation of that. Then 420 will be made out for the conduct prior to issuance of check, not by the conduct of issuance of check.
That government is
By
not in that.
mere issuance of check from a closed account. Then you see in all the cases where 138 cases are filed, the moment the check of a closed account is issued and it gets bounced, you will impute 420. It has a very wide-ranging impact. The action to refund the money, the entire jurisprudence of Negotiable Instruments Act, particularly check bouncing, is that it is essentially a civil dispute and given the color of a criminal act by virtue of Negotiable Instruments Act. So mere action of return of money by a check, I don't agree. 415 will not come.
So
ठीक है, देखते
that I must say that the government has not in the complaint itself a lot.
Neither averment is in the complaint, nor it is there in, and otherwise judgment also does not reflect that. Yes, so far as this
130.
NI Act 138 is concerned, certainly it is made out in the sense that check has been issued, it has bounced, but otherwise it is a premature presentation. Your right to file a case will be protected. You should be happy with the money.
Yes, sir.
420 जाने दीजिए.
Yes, sir.
ठीक है. लिखना पड़ेगा, अब हमको इस जजमेंट को डिस्टिंग्विश करना पड़ेगा. आ गया है तो हम करेंगे जरूर, हम छोड़ेंगे नहीं ऐसे.
On
और थोड़ा
this issue,
सोच
Lordship,
समझ
I
के
have
करें।
filed several judgments on this issue. On the closed account, I have all the cases are arising, delivered by the Kerala.
We will distinguish it. Now,
Yes, sir.
now you cite one judgment of Jharkhand High Court
Yes,
of
yes,
Kerala. Our judgments are not cited anywhere because our councils don't read our judgments.
Lordship, one, I have
No, Your Lordship, everyone
It is a fact. Nobody reads it.
No,
I
everyone
know.
reads.
one case judgment I have also seen that has been quoted in the judgment itself, Your Lordship,
Yes.
of this honorable court, but that is in 482 case, Your Lordship, that has been dealt with. That is 2015 case. That is on page number 39.
13.
39.
39 of?
Main petition, Your Lordship.
Running page 30.
Page number 39. On the top three line, Your Lordship. Similarly with the number 705 of 2015. Of this one,
What does it say?
that I had not bring, Lordship. As because that is that has been challenged in 482.
The
Criminal
word-
Division 705.
Yes, sir.
That is on another point, Your Lordship, that the amount was filled by another person.
That is of no use. There is 498A also involved somewhere.
No.
I'm just, you see,
No.
there is a mention of PCR case 498A.
No, that is with Manoj Jain relationship with Manoj Jain and the petitioner, Lordship.
Okay.
That's all.
लिखिए. The learned counsel for the parties are present. The learned counsel for the petitioner submits that the basic ingredient for offence under section 420 of Indian Penal Code is completely missing in the present case. He has submitted that there was land dispute between, there was a transaction of money in connection with sale and purchase of land, and when the sale deed was not executed, the complainant approached the petitioner for repayment of money, and consequently a check was issued for the entire amount. He submits that so far as the transaction regarding transaction of money regarding sale and purchase of land is concerned, there is no allegation in the entire complaint that the same was suffering, the same had any element of cheating. However, the learned courts, while convicting the petitioner for offence under section 420, have found the petitioner guilty of section 420 of negotiable of the Indian Penal Code on the ground that the petitioner had issued check from of a closed account, and therefore at the time of return of the check amount, the petitioner had no intention to return. The learned counsel has placed section 420 of Indian Penal Code and has submitted that the intention to cheat should exist right at the time when the money was taken by the petitioner from the complainant, and the act of the petitioner to return the money through a check, even if it was from a closed account, does not constitute cheating. He has further submitted that the petitioner has also been convicted for offence under section 138 of Negotiable Instruments Act, The legal notice in the present case was issued on 27/9/2014 and the complaint was filed on 17/10/2014. He submits that there is no evidence on record in connection with service of legal notice, and even if it is presumed that the legal presumption of service of notice would be only upon expiry of 30 days, and thereafter 15 more days was available to the complainant to return the amount, and the cause of action to file the complaint case would arise only after 45 days from 27/9/2014. Accordingly, the filing of complaint on 17/10/2014 was premature, and therefore the conviction of the petitioner for offence under section 138 of Negotiable Instruments Act is perverse and calls for interference. He submits that the judgment, दोनों लिखिएगा, 420 and 138 is perverse and calls for interference. The learned counsel, appearing on behalf of the opposite party, while opposing the prayer of the petitioner, has submitted that in revisional jurisdiction there is no scope for reappreciation of evidence. He has further submitted that even if at the time of initial transaction of money regarding sale and purchase of land, there was no intent to cheat, but at the time of issuance of check, the petitioner had cheated the complainant inasmuch as the check itself was issued from a closed account, and the petitioner was very much aware that under no circumstances the check could be encashed. He submits that on this ground, ingredient of section 420 is made out. He has relied upon judgment passed by Honorable Kerala High Court dated 30th of November 2023 and has submitted that similar view has been taken by the Honorable Kerala High Court that issuance of a check with respect to closed account would amount to cheating. However, from the perusal of the judgment passed by Honorable Kerala High Court, it is apparent that the case was instituted under section 420 of Indian Penal Code and was sent for investigation, and thereafter the accused was tried under section 420 of IPC. Right?
Yes.
And in the said case, one of the fact was that the money was sought to be returned by issuance of check which had also bounced, and therefore there was a discussion in connection with section 138 of the Negotiable Instruments Act. In the said case, there was an allegation that money was taken by the accused to arrange for a job which he could not, which he did not abide by, and he did not abide by his promise. And it was alleged that the accused had deceased the informant of the case. So far as the offence under section 138 of Negotiable Instruments Act in the present case is concerned, the learned counsel submits that even if the timeline is not as per law, the right to file the complaint by is still to be has to remain intact, and it may be open to the petitioner, to the complainant, to file a fresh complaint with a petition for condonation of delay. That's it. दिखाएं अभी 3:30 बजे आज 3 बजे एक मैटर रखे हुए हैं। इसको करेक्शन होके आने दीजिए। नहीं नहीं, हम रिजर्व नहीं करेंगे, इट्स अ ह्यूज बर्डन। हम इसको परसों फर्दर लिखा देंगे।
ठीक।
ठीक है, हो सकता है हम बना के लेके आए, नहीं तो हम लिखा देंगे। अभी माइंड मेकअप किया हुआ है।
We will come on.
You please be there. If you are there, it's okay. If you are not there, then also I'll do that. Today is 14th.
Yes.
16 को कुछ रखें क्या? एक petitioner has relied upon, आप कौन कौन सा judgment rely
Only
किए
one
हैं?
judgment is about that. 3 judges bench.
हाँ हाँ. Has relied upon judgment passed by the Honorable Supreme Court in AIR, reported in AI 2015 SC 157, Yogendra Pratap Singh versus Savita Pandey.
Paragraphs 32 to 39.
So Savitri Pandey, Savitri Pandey.
कौन सा सावित्री पांडे?
वही जो सविता पांडे बोली, सावित्री पांडे।
ओ सावित्री पांडे, सविता पांडे। आप लाए हैं वो कि राइट टू फाइल कंप्लेंट विल रिमेन इंटैक्ट?
No, Lordship, I will provide that judgment. I will provide.
अरे मेरा जजमेंट सब हमको तो याद
नहीं, हम
है।
दे दे रहे हैं सर, अभी तुरंत ही दे देंगे।
सुप्रीम कोर्ट का नया जजमेंट है,
हाँ।
अभी हम रिसेंटली उसको रिलाई भी की।
Yes, Lordship, I had seen
You have seen that
that
judgment?
judgment.
आप देख लीजिए प्लीज। हम अपना जजमेंट रिलाई करके हमको मन नहीं लगता लिखने में। सुप्रीम कोर्ट का जजमेंट है, उसी को रिलाई करेंगे। The arguments are concluded. Post this case for further dictation they are करेंगे। 16th को हम लिखाएंगे।
जी।
हो सकता है कि हम करके लेकर आए।
जी।
Because it is going to have some impact, and I have to distinguish Kerala High Court judgment carefully. I will see the judgments which has been relied upon in that case, and then I will pass the judgment.
We are
ये दोनों उनको बोलिएगा निकाल के जब तक।
This case from supplementary list for financial item 1, WPS 1754 of 2023.
He had sent a online request. I think he's online. He maybe wanted to share the screen.
Where is the other side? Where is the other side? They were supposed to bring some format.
Yes, ma'am. We are-
Where are they? Yes,
Yes, Lordship, we have brought that.
it's your turn. Where is it?
Yes, Lordship, we have brought that. I am searching file. Give me file.
We have also taken out that format.
Yes.
My colleague is also having it.
Sure, let's just have a look at it. It's the same?
Yes, but almost the same. Some wording lines have one or that there, but substance is same. All identical to page 37 of the counter affidavit filed by DPS.
It's the same.
No, my lord, no, my lord,
Let
not
us-
same, your lordship.
Okay, what is the
Subject-
difference? Let us.
My lord, kindly come at top, your lordship.
Hmm.
I, my lord, kindly recall your lordship. Yesterday, your lordship, I brought into your lordship's notice that prior to 2013, your lordship, there was two types of the caste certificates, your lordship. One for the educational purposes, your lordship, and one for the employment, your lordship. Thereafter, your lordship, the forma was changed and one caste certificate was being issued, your lordship, from 2013 onwards, your lordship. My lord, this is the forma of for all works, your lordship, kindly see at top जाति प्रमाण पत्र सभी कार्यों के लिए. Then your lordship, at bottom, your lordship.
No, when you say that there were two separate pro formas under the previous regime, where is that?
My lord, that is on the record, your lordship.
Let us see. Two pro formas. Where are those pro formas?
My lord, kindly see Annexure D.
Annexure D.
Annexure D, your lordship. Start, your lordship, page 36 and relevant is at page 37.
Counter affidavit.
No, counter it.
Annexure D. Then this is 37 is the certificate.
My lord, that is your lordship.
Yes. There is no
They can't
format.
have-
He has just simply mentioned that it is for education purpose.
Huh.
In handwriting, he has mentioned.
And my lord, my lord, in handwriting itself.
No, there
your
is no
lordship.
format as such. I just can't understand what is the difference between for education purpose and for this. And it is not your case that he does not belong to state of Jharkhand.
My lord, that is, my lord, I am coming on that issue, your lordship, later on, your lordship. First of all, your lordship, I will have to satisfy your lordship about the query raised by your lordship about the difference in the caste certificate.
Yes,
your
you tell
lordship.
us what
First
is
of
the
all, your
difference.
lordship, I have argue on that issue, your lordship.
Yes,
This
please
is the caste certificate submitted by him, your lordship.
Yes.
That is, my lord, that is not in per forma. I mentioned in Annexure C, your lordship. First, your lordship, kindly see Annexure C. At page 35. Jharkhand प्रशासन ने यदि your lordship.
So this is not the format.
Lord, that is not in format, your lordship. Format has been provided by the state format, your lordship.
Yes.
This is the format, your
Yes,
lordship.
kindly.
Huh.
No, this is not the format.
No, that is the, your lordship, that is my notice, your lordship.
That is your notice.
That is my notice, your lordship, directing the candidates to submit the caste certificate in forma prescribed by the state government, your lordship, by virtue of the order dated 12/11/2018, by virtue of the order 22/10/2008, your lordship.
Yes.
Kindly, I may read, your lordship, as a whole, your lordship. झारखंड प्रशासनिक सेवा संवर्ग के उप समाहर्ता पद पर सीमित प्रतियोगिता परिषद नियुक्ति हेतु पूर्व में प्रकाशित विज्ञापन के आरक्षित कोटि के सभी अभ्यर्थी तथा पिछड़ा वर्ग अनुसूचित विदिन ब्रैकेट 2 अत्यंत पिछड़ा वर्ग अनुसूचित को कार्मिक प्रशासनिक तथा राजभाषा विभाग के ज्ञापन इतना 1007 my lord, I have also, your lordship, given your lordship that notification dated 29/5/2012 द्वारा निर्धारित भी पद पर योगदान क्रीमी लेयर प्रमाण पत्र सहित में वैध एवं अनुसूचित जाति और अनुसूचित जनजाति को कार्मिक प्रशासनिक सुधार राजभाषा के पत्रांक दिनांक इतना के द्वारा निर्धारित विहित प्रपत्र 1 में दैट इज योर लॉर्डशिप फॉर SC/ST झारखंड राज्य के उपायुक्त निर्गत जाति की 100 अभिमानित प्रति 12/11/2018 तक स्पीड पोस्ट सच एंड सच हाथों हाथ कार्यों में इतना के द्वारा प्रत्येक उपलब्ध कराना होगा. But if this is the forma, your
You
lordship,
said
one.
that you have given the this notification 29/5/2012.
Your
Where
lordship.
is that?
My lord, that is ये for SC and ST, your lordship, that is your lordship 22/10/2008, your lordship.
22/10/2008, right?
That
Yes,
is-
that I have.
Your lordship.
Now you see the format.
My lord,
Where is the
thereafter
format?
in bottom, your lordship, that is format, your lordship.
Yes.
Prapatra 1.
Where is Prapatra 1?
My lord, उसके बाद वाला
Okay, Prapatra 1.
Prapatra 1.
Okay. Yes.
This is Prapatra 1, your lordship. That was required. that was required, your lordship, and if your lordship will compare with the caste certificate submitted by the petitioner, your lordship, that is not in proper form. My lord, at top it is to be mentioned, your lordship, at for forma 1.
So this column pro forma 1 is missing. Let us see what all is missing.
My lord.
This
Sir,
pro
at
forma
top,
1 is
your
missing.
lordship, हाँ, pro forma 1 is missing, your lordship. उसके बाद है संख्या, यहाँ पर प्रमाण पत्र संख्या, वहाँ पर संख्या है, ऊपर है सभी कार्यों के लिए, यहाँ पर कुछ नहीं है, फॉर्म जाति प्रमाण पत्र, नीचे लिखा हुआ है शिक्षा हेतु. Might he has submitted the application for educational purposes, and as such it has been issued. Because your lordship, prior to 2013, two types of the caste certificate were being issued, one for the educational purposes, one for the employment purposes. This is of 9/3/2011, your lordship. The criteria for verification of the about the candidates was different, your lordship. For
No,
educational.
you see, we can't have a lecture like this. You have to show it whatever you want to, you have to say. We just, you see, when you cannot, you assume that I do not know. Firstly,
My lord, how I can
no,
assume,
no,
your
you
lordship?
please assume that I do
My
not
lord.
know. When you say that there was a prescribed format, different formats was to be, you just have to place it before the court.
My lord, I have.
You show me, you said
Kindly see,
2013,
your
the
lordship,
procedure
kindly-
prior to
My lord, I
2013.
was explaining, your lordship. My lord, the forma is before your lordship. I have to
There is
only.
no material difference.
My lord,
You
that
see,
is- my lord, that is
संख्या
अपनी-
और प्रमाण पत्र संख्या, इसमें क्या फर्क है?
उसके बाद देखा जाए,
हाँ, क्या फर्क है? आप हमको बताइए, संख्या एंड प्रमाण पत्र संख्या में क्या फर्क है? कोई भी भाषा में हमको समझाइए. I am ready to hear in any language
my
of your
lord,
choice.
My lord, subject your lordship's pleasure, your lordship. I may be allowed to explain.
I-
My lord, previously, your lordship, the caste certificate, the educational purpose certificate, there was no different for forma for the SC, ST, BC1 and BC2. There was no different for forma, your lordship. In one for forma, your lordship, for the educational purposes, the same were being issued, your lordship. Thereafter, your lordship.
I am not aware of any such
But
pro
that is-
forma.
My lord,
अरे
since
नहीं,
we.
इतना नहीं.
ये
आपको
इसमें देखा-
लगता है आप बहस करके चले जाएंगे और हम आपका ये लिखेंगे that there was one performer. Then that judgment will become perverse.
My lord, it is my duty to your lordship explain.
So you show me that there was one performer.
My lord, I am
This
trying
was
to-
the circumstances. It led to this changes, and therefore this particular there was a change in the required format.
My lord.
आप हमको पहले ये कंपेयर करके ही बताइए.
जी,
आपको वो
आप
कहानी बात
इसमें आप पहले ये पेज 37 पे my lord kindly turn to page 37.
हाँ,
Of
37
my
हम
counter
37 में ही अटके हो.
जी,
बताइए.
37 में your lordship. My lord kindly see, अब ऊपर ने प्रमाणित किया, प्रमाण संबंध संख्या दिनांक
ये जो सेंटेंस है ना, यहाँ से पढ़िए और मिलाइए.
मैं प्रमाणित करता हूँ कि सुनील कुमार सच एंड सच यहाँ पर मैं प्रमाणित करता हूँ, और वहाँ पर लिखा हुआ हो जाता है कि प्रमाणित किया जाता है. Then your lordship may
दोनों में
ask,
फर्क?
then my lord, I was saying your lordship, then your lordship may ask that whether there is any difference or not, your lordship. My lord, I am not on that, your lordship. I am on the contents of the both, your lordship.
Yes, kindly
Madam.
tell us. What
इसमें
is
है
the
कि
difference?
प्रमाणित किया जाता है. मैं प्रमाणित करता हूँ कि सुनील कुमार राय सच एंड सच जो पुत्री पुत्र सच एंड सच, जो ग्राम सच एंड सच, डाकघर धनबाद धनसार जिला के वासी हैं और झारखंड जनवासी हैं और अनुसूचित जनजाति, अनुसूचित जाति. उसके बाद देखा जाए अत्यंत पिछड़ा वर्ग, उसकी इसमें है अत्यंत पिछड़ा वर्ग में आते हैं. और ये जो परफॉर्मा 1 है उसमें पिछड़ा वर्ग और अत्यंत पिछड़ा वर्ग का नहीं है. That is your lordship exclusively for the SC and ST candidates, your lordship.
Yes.
Thereafter, your lordship, second paragraph, यहाँ पर है इनकी उपजाति सच एंड सच है, ठीक है, ये है. और उसके बाद यह प्रमाण पत्र अंचल अधिकारी धनबाद जिसका प्रमाण पत्र इतना के आधार पर निर्गत किया जाता है. और अब इसमें देखिए, इसमें पैराग्राफ 2 में क्या है. ये अंचल अधिकारी पर करते थे, अब है कि वो खुद करेंगे. श्रीमती सच एंड सच उनका परिवार तो साधारणतः इतना राज्य में निवास करते हैं. There is no mentioning your lordship ये प्रमाण पत्र अंचल अधिकारी etc. that is missing. Then your lordship कार्यालय की मुहर नोट जो लागू नहीं उसे काट दे. उसके बाद ये प्रोविजंस दिया गया है कि आफ्टर रीऑर्गेनाइजेशन एक्ट which caste has been included as a SC and ST for the state of Jharkhand also your lordship by virtue of the presidential order your lordship. That is mentioning your lordship. That all those facts is not in this your lordship. Caste certificate as submitted by him. That is your lordship material. My lord, as per me, subject to your lordship's acceptance, your lordship. That is the difference in your lordship.
Just tell us one thing.
My lord,
This caste certificate was issued on 9/3/2011,
my lord,
right?
my lord.
This circular was issued on
2008.
2008.
2008. But per forma was mentioned your lordship for employment your lordship per forma 1. That is before your lordship. Per forma. This is not in per forma 1.
Your, as per you, the format in which he was supposed to furnish is this format, 2008 format, right? Then why this authority has issued the certificate in the year 2011?
My lord, how I can explain?
You
what-
have to explain,
My-
the
my-
state
my-
has to
my-
explain. You see what is happening.
My lord,
The right of reservation, be it OBC, SC, ST, is being denied on one or the other technical ground.
my lord.
And the authorities who are issuing the certificate, right, they are not aware. Now this particular certificate, caste certificate,
To that extent, your lordship is correct. On that
caste
issue, I am.
certificate issued in the year
do-
2011,
My lord,
you see, these are the persons whom you have to extend your helping hand to, because they do not know their rights. ये तो उनमें से है जो बताना है कि आपका ये right है.
my lord, he is
Huh, so-
teacher. He is
Maybe
teacher.
we are not on what he is. He may be a scientist. Who bothers about it? But as per the constitution makes no difference. He may be a multimillionaire, but the constitution makes no difference. He has a reservation under the
My lord, that
provisions
is
of
correct, your
constitution,
lordship. That is correct, your lordship.
right?
My lord,
Therefore, the
that is-
state is issuing a certificate in 2011, ignoring the format which has been prescribed in 2008. How is the candidate to be blamed
My
for
lord,
that?
my lord, for a moment, your lordship, kindly consider. My lord, which type of the application was submitted by the candidate for issuance of the which certificate? That is the material, your lordship. My lord, if suppose your lordship, I have submitted an application before the authority concerned, your lordship, prior to 2013, your lordship, for issuance of the caste certificate for educational purposes, your lordship. Then it will be issued, your lordship, for the educational purposes. If I have submitted a caste application for providing the caste certificate for employment purpose, then it will be issued, your lordship. Then your lordship,
So I
it
want
is
to
dependent
know-
upon the candidate
So
who is.
I want to know, where is that circular which prescribes that caste certificate for educational purpose? Where is that circular? Your mere statement in the court will not suffice.
My lord, that is correct, my lord.
Yes.
My lord, I am not.
And just tell us one thing,
My
a
dear.
person who is applying for a caste certificate,
Hmm.
how are you concerned? For what purpose is he applying for?
My lord, kindly.
No, let us
my
understand.
lord, kindly appreciate my
Mr.
problem,
People-
your lordship. My lord, kindly appreciate my problem, your lordship. Once the advertisement is issued and subsequent corrigendum is issued, your lordship, then I have to apply the same criteria, your lordship, to all candidates, your
That's
lordship. My lord, I cannot deviate from any condition, your lordship, stipulated in the advertisement as well as in the subsequent advertisement, your lordship. If I am deviating, your lordship, the same will amount to changing the terms of the advertisement, your lordship, and instructions issued by the JPSC, because it has to be applied uniformly to the all candidates, your lordship. I cannot deviate it, your lordship. Secondly, your lordship, what is my duty and what I can do, your lordship? My duty is only, your lordship, limited to issue the advertisement, your lordship, in terms of the advertisement or the requisition of the state government, and I have to follow, your lordship. My lord, I have seen several, we are facing, my lord, there is no deviation from the advertisement, your lordship. But one set of is being one set of the cases is being filed, your lordship, that we are hyper technical and we are rejecting the candidature on the basis of, your lordship, the caste on the basis of the little difference in the caste certificate. Second set of the cases is being filed, your lordship, that I have given relaxation by deviating that, your lordship. I have given relaxation to those candidates which is not permissible. We are facing both, your lordship. But we have not deviated from any terms of the advertisement, and my
No,
lord,
we understand your situation, that you have to strictly follow whatever
my
it
lord,
is.
and my lord, kindly have a look to the, my lord, this aspect has already been considered by this.
That is why 226. Otherwise, what is the big idea of having 226?
My lord, this aspect has already been considered, your lordship. So far the performa is concerned, your lordship, and one question has also been raised, your lordship. I will come on your lordship later, your lordship. One aspect has also been raised, your lordship, that I am by birth SC and ST, your lordship. And as such, there is no need of any caste certificate. That aspect has also been raised.
No
in
need
other,
of a caste certificate. That declaration is required.
Huh?
Unless you have a
my
caste
lord, that has
certificate.
been argued in other cases, your lordship, before your lordship. Kindly remember, your lordship.
I don't remember.
Pawan Urao case, your lordship. That is pending consideration before your lordship.
Declaration is certainly required, a certificate is certainly required, but we are absolutely clueless. Where is your circular that different caste certificates were to be issued?
My lord.
Yes, madam, you just tell us. After this circular of 2008, why a different format has been used by your officer while issuing a caste certificate?
Your ladyship in this, the only difference is that
There is no difference. Technically, you concede that. What is the difference between the two? The only thing is that in this format 1,
in this Savikaryo Vidya it has been written in this 2008.
yes,
In this your ladyship Siksha Hetu case.
Siksha Hetu, he has written it in own pen.
Own pen.
So?
Yes, your ladyship.
How does that make a difference? You just tell us. How does that make a difference? Do you want to say that the scrutiny while issuing caste certificate for educational purposes is not too hard? It is more difficult to get admission in educational institution than to get a job, isn't it?
My lord, both are difficult, your lordship. Both are difficult, your lord. My lord, we are seeing, your lordship.
Difficulty, your ladyship.
My lord, they are not getting
These
admission,
days
your lordship.
appointment is
If,
quite-
my lord, I am SC and ST of this state. My lord, if I am going, your lordship, outside, your lordship, apart from, your lordship, union educational institutions, your lordship, central government educational institution, then I am being treated as a general, your lordship, and as such it is very difficult for the reserved category candidates to get
You
admission
see,
in other states,
we
your
are
lordship.
not concerned with other states. We just want to know that this particular format in 2011, why an authority will issue a caste certificate in this particular format when there is a prescribed format for issuance of caste certificate?
My lord, that was.
And
my lord,
how the candidate is to be blamed for that purpose?
My lord, it is not. My lord,
Mr. Piperwal, this is not an isolated case.
Madam,
I am saying so much because of the reason that some kind of guideline is required to be given to these authorities, and the deputy commissioners, they are required to follow it up. There are so many candidates who are coming, and because of this kind of mismatch in caste certificate, their candidature is being rejected, and consequently the meritorious candidates of these communities are not getting the job.
एक देखा जाए ना, वो जो सर्कुलर है 2008
दिखाइए आप
का,
सर्कुलर दिखाइए आपको दिखाइए।
क्लॉज 2 में देखा जाए, clause
देखिए
2
ये केस आपको बता दे रहे हैं हम तो नहीं, आपका एक बात भी सुनिए।
नहीं मत सुनिए, हम I am not concerned with the result.
I am absolutely,
I am,
you know,
my lord, I am here to assist your lordship. I am not concerned
because
with
this
the
is
result.
you just cite those judgments with regard to the format.
My
The
lord,
numerous judgments
I
you
am. your
cite
lordship.
those judgments.
My
We
lord.
will see what is to be
My
done.
lord. Secondly, your lordship.
And state will have to explain how in 2011 a format which has the old format has been utilized for issuance of a caste certificate. Right?
My lord, second aspect, your lordship. My lord, can you have a look to performa, your lordship? That I have marked. I have marked for me, your lordship, but second copy which was I have kept for
You
your
cite your
lordship.
judgments you want to cite. And then I'll ask the petitioner to cite their judgments on format.
91 of 2020. My lord, I have marked, your lordship. If it is not in performa, your lordship, then it is to be rejected, your lordship. That is the case, your lordship, arising out of the single judge, your lordship. That is Rajkumar Mahato case, your lordship. And now it has been referred to the larger bench.
This
But-
judgment has been referred to
larger bench, your lordship, because your lordship, my lord, altogether 49 writ applications were dismissed, your lordship, by the honorable read court, your lordship, of the different selection process. That is, your lordship, this is the judgment, your
You
lordship.
just placed this judgment. Please just don't tell us that you have just marked.
My lord.
There is a recent judgment of the Honorable Supreme Court also on this.
My lord, that is against her, your lordship. That is the
Maybe
I have not-
against her. We are not bothered about it.
My lord, I am also not bothered. My lord, I am coming, your lordship. Firstly, your lordship, what is the requirement? And whether the High Court, while exercising power under Article 2 to 6 of the Constitution of India, can relax the condition of the advertisement or instruction issued by the Public Service Commission. My lord, this is the question, your lordship. My lord, admittedly there is two facts, your lordship. The concealment of the fact, your lordship, in the writ application, the petitioner has said that I am not aware about the notice annexure C, your lordship. That is the notice published by the JPSC for submission of the caste certificate in prescribed format. But I have brought into the notice of your lordship by way of filing the counter affidavit that he was well aware and he complied the same and has submitted the caste certificate along with other documents, your lordship, that is annexure D, your lordship. But in the writ application, he has not mentioned the same. That amounts to concealment of the material facts, and on the basis, if there is any concealment of the material fact, then the petitioner is not entitled for any benefit. My lord, I will cite the judgment. Second aspect, your lordship, in per forma, your lordship. What is the per forma, your lordship, and what is and whether it and your lordship, the requirement of compliance of the same, your lordship. My lord, kindly see, your lordship, para 2. I have marked also, your
Yes,
lordship.
according to the petition.
Relevant, I have marked, your lordship.
Yes.
In per forma, and if there is instruction, that has to be made applicable to all candidates. There cannot be any deviation from the instructions, your lordship. Your lordship will find at page number 2, on hyper-technical ground, it cannot be rejected. A ground has been taken at page number 2, your lordship.
Yes. This was in the format of central government.
Central government.
Format of central government is certainly different from the
Certainly
format
different,
of
your lordship, certainly different.
We have seen that. So it is not a case of central government format.
My lord, that is not in the case of the central government, but it has also been taken note, your lordship, that if instruction is for the submission of the caste certificate in particular format, that has to be submitted, and there cannot be any deviation from that, your lordship. That is mentioned, your lordship. Para 7 onwards, your lordship.
That's right.
At page 5, your lordship, you will see that he has not submitted the caste certificate in format as prescribed in the advertisement.
Yes.
At top 5, page number 5.
Is there any condition that the certificate has to be issued within 3 years? ऐसा कुछ है?
वो होता है केवल-
इसमें नहीं है ना?
नहीं, इसमें नहीं।
Very good.
इसमें वो केवल होता है BC1 एंड BC2 का होता है। हर एक 3 साल पे उनका क्राइटेरिया चेंज होता है, एंड द पर्सन्स बिलोंगिंग, दैट ऑर्डर हैज आल्सो बीन पास्ड बाय योर लॉर्डशिप. I may be in BC1 at present, your lordship. I may go in BC2 after 3 years.
That side we have seen it. Any other judgment you want to cite? Any other judgment?
There end. पेज 9 में देखा जाएगा मुझे, नीचे एकदम बॉटम में एकदम देयर इज मटेरियल इज इन कॉन्टेक्स्ट ऑफ फॉर्म 1 फॉर्म 2 यूपीएसएस विद एनेक्सर 3 टू द इफेक्ट दैट द एनेक्सर देयर इज डिफरेंस पेज 9 में बॉटम.
That's right.
Then your lordship, page 10, your lordship, at bottom, may I take your lordship page 10? the issue has been raised before this honorable by the use under 226 of convention by taking the plea that in the course of the party is too hypertechnical and as such the same question. The question here is whether the condition is stipulated in the advertisement, if not being followed, what would be its consequences? Then, Your Lordship, it is the next page, Your Lordship. It is the settled position of law that the condition is stipulated in the advertisement is strictly to be adhered to. Reference to this regard may be made to the judgment entered by the Honorable Apex Court in such and such, such and such, such and such. Then, Your Lordship, similar view has been taken by the Honorable Apex Court in Bedanga Tarkidar, Your Lordship. That is important, Your Lord, versus Safidullah Khan, para 29 from the court will be quoted here in after. We have considered the entire matter in detail in our, it is too well settled to need any further indication that all the appointments to the public office have to be made in conformity with Article 14 of the Constitution of India. In other words, there must be no arbitrariness resulting from any undue power being shown to any candidate. Therefore, the selection process has to be conducted strictly in accordance with the stipulated selection procedure. Consequently, when a particular schedule is mentioned in an agreement, the same has to be strictly maintained. There cannot be any relaxation in the terms and conditions of the admitted unless such a power is especially reserved. Such a power could be reserved in the relevant specific, even if power of access provided in the rules, it must still be mentioned in the advertisement. In the absence of such power in the rules, it could still be provided in the advertisement. However, the power of selection, if exercised, to be given due publicity. This would be necessary to ensure that those candidates who become eligible due to the relaxation, that is important to know, are afforded an equal opportunity to apply and compete. Relaxation of any condition in the advertisement without due publication would be contrary to the mandate of equality contained in Article 14 and 16 of the Constitution.
Yes, I got it.
My Lord,
Any
if your
other
Lord-
judgment?
My Lord, I will cite your Lordship 4 and 5 statements. Your Lordship. Then your Lordship, these several issues have been dealt in Charles, etc. Your Lordship. Thereafter, your Lordship, come to page 13. Your Lordship.
Page 13.
Second para, Ram Kumar Gujroya. My Lord, Ram Kumar Gujroya case is in the different line, your Lordship. My Lord, in that case, the submission of the OBC certificate was introduced while publication of the result. And as such, your Lordship.
We are aware of that.
My Lord, I have argued, your Lordship. Then, your Lordship, kindly turn to
The cutoff date also cannot be shifted.
my cut-off date also cannot be shifted. My Lord, this has been your Lordship referred before the Honorable Larger.
Where is the terms of reference?
My Lord, I am giving you. My Lord, this is arising out of the, my Lord, the batch of the cases passed by the Honorable Reed Court. This has been informed, your Lordship, and thereafter, your Lordship, the reference has been made by the Honorable another division bench arising out of the same order, your Lordship. But in different cases, your Lordship, batch of the cases was there. This is the reference order before the larger bench.
Where is the terms of reference? These are not, we are not concerned with any of the terms of reference. These terms of reference are not relevant for the present case. LPA 64 of
64 of
2020,
2020.
2nd March 2023.
Order dated 2nd March 2023. Second. My Lord, then you have to kindly turn My Lord, this is the, your Lordship, another LP, your Lordship, about the cut-off date, your Lordship, etc.
No, we are not concerned with cutoff date.
My Lord, that is the issue, your Lordship. When there is any stipulation made in the advertisement, your Lordship, that is to be followed, your Lordship. On that issue, your Lordship.
Which paragraph are you
My
referring?
Lord, I am indicating all relevant paragraphs, your Lordship. I am giving you relevant para.
In that case, the appellant has realized his mistake and thereafter he submitted another certificate. It is not a case of that nature where he realized his mistake and
In
submitted
this
another
case, Your
certificate.
Lordship, that is not a question of realization, Your Lordship. It is a case of misconcealment of the material fact and non-submission of the caste certificate in forma prescribed in the notice, Your Lordship. That is the case, Your Lordship. And for that, Your Lordship, I am taking to Your Lordship that judgment, Your Lordship, that is very important, Your Lordship. APF 469 of 2015. Of 2015.
वहाँ नेट का एक्सेस नहीं है कंप्यूटर में. You have your access.
Net है.
So
Sorry?
that senior can also share. They're just taking out the orders and they're putting it in our office with that.
My Lord, kindly turn to page number 2. And this has been affirmed by the Honorable Supreme Court, Your Lordship, by 3 judges, Your Lordship. This is the order of passed by the Honorable Supreme Court. Then I will show Your Lordship. This order has been affirmed by the Honorable Supreme Court by the 3 judges. Bench.
इसके कॉपी ले लीजिए.
हाँ, दे दें.
कर लीजिए.
My Lord, I will be giving you.
हाँ, you provide.
In fact, Your Lordship.
Because then I will forget that while citing this judgment upheld by Supreme
My
Court.
Lord. My Lord, in this case, Your Lordship, issue was Your Lordship, contention was Your Lordship, that he was also SC. My Lord, I am only citing the judgment pertaining to SC candidate, Your Lordship. My Lord, kindly see the page 2.
Yes.
Factual matrix. Next, as per the advertisement, residential certificate issued by an officer not below the rank of sub-divisional officer was to be given by the candidate on or before the cut-off date, that is 9th March 2012. The appellant supplied residential certificate issued by the circle officer who is below the rank of sub-divisional officer. Next, the appellant corrected his mistake and gave residential certificate issued by the sub-divisional officer at the time of his interview, that is on 1st November 2012, that is after the cut-off date. As the residential certificate was not given on or before 9th March, the result of this petition appellant was not published or declared by the Jharkhand Public Service Commission. And hence this appellant prefer edit petition such and such.
Essentially, it is on the basis on the fact of a submission of a certificate beyond the cutoff date.
Solution, Your Lordship, of the that is correct, Your Lordship, and Your Lordship and failure on the part of the candidates in not complying the terms of the advertisement on 2 issues, Your Lordship. My Lord, in this case, Your Lordship, several other issues has also been taken into note, Your Lordship. That, Your Lordship, I may be allowed to read page 3, Your Lordship. Only, Your Lordship, I am taking to. Because, Your Lordship, there are several cases pending before Your Lordship on the caste certificate on different issues, Your Lordship. That is, Your Lordship, the crux of, and as such, I am taking Your Lordship to those paragraphs, Your Lordship.
Just number
469
469.
of 2015. 50. तीन आर्गुमेंट कन्वास by the learned counsel for the appellants, Your Lordship, such as इसमें भी ये था कि that was not in caste certificate was issued by the circle officer not in performa by not an authority. It was rejected. That is the sum and substance of the case, Your Lordship. Learned counsel was said that in fact this is issued by the certificate Itna has already submitted prior to the cut-off date Itna. My Lord, he has submitted the caste certificate, residential certificate issued by an authority not mentioned in the advertisement, Your Lordship. And here is the case, Your Lordship, he has submitted the caste certificate not in performa as indicated in the press communique.
The only difference is pro forma. Any person who is not Suppose there is a circle officer mentioned that he has to issue a caste certificate. Then if the caste certificate is issued by somebody else, certainly it cannot be accepted.
My
Isn't
lord, I
it?
am deeply obliged, Your Lordship. I am deeply obliged.
If the authority is somebody else, then it cannot be accepted. Fair enough.
My-
Right?
my lord,
But authority, there is no dispute regarding authority. The
My lord,
dispute
there
is
is no
only with
dispute
regard
about
to.
I am on the legal position, Your Lordship. My lord, what would be the consequences, Your Lordship, in not following the terms of the advertisement?
That's
Suppose, Your Lordship, at that point of time when the petitioner has submitted this caste certificate, Your Lordship, several other candidates had also may have the same caste
Could be.
certificate, but since they were aware about the terms and conditions, they read it out, Your Lordship, and as such they did not submit the same, Your Lordship.
That's right.
They have not submitted the same before the JPSC, Your Lordship, and as such their candidature has been considered in the undeserved category.
That's
My lord, the facts is, Your Lordship, that any terms and conditions is mentioned, that has to be followed by all candidates. Any deviation, Your Lordship, will amount to, Your Lordship, arbitrary action, Your Lordship, and it will be called, Your Lordship, deviation from the terms of the advertisement, which is not permissible. Similar is the position with the cut-off date, Your Lordship. That has been dealt in this case, Your Lordship, both, Your Lordship, facts has been taken into consideration by the Honorable Division Bench, Your Lordship. This is, Your Lordship, facts, Your Lordship. Thereafter, Your Lordship, it is further submitted by learned constable that the insertion is of a very condition the public advertisement, especially clause number 28(1), which is at annexure 12 of the memo of this letter is unconstitutional in view of the decision rendered by the full bench of this court, such and such. My lord, in this case also, Your Lordship, the pleading has been taken, Your Lordship, that even if it is issued, that is not mandatory. Para 35 honors that I have read out, Your Lordship, yesterday. This is the condition that even it is issued. First of all, he has submitted that I am not aware. Second, Your Lordship, the contention of the petitioner is this, Your Lordship, that even if it is issued, that is unconstitutional. That is the pleadings of the petitioner. And same is the fact in this case also, Your Lordship. It is further said by the unconstitutional that the insertion of very conditions public itna, which is at page of the memo of the is unconstitutional in view of the decision rendered by the full bench of this court reported inserted. This applicable matter has not been properly after the and hence the judgment of itna, such and such. Thereafter, Your Lordship, Ram Kumar Gijura. It is also submitted that learned constable that this applicant is a scheduled tribe category candidate and therefore he can submit residence even after the cut-off date as per the decision rendered by the Honorable Supreme Court reported in equivalent to such and such. Thereafter, Your Lordship, I am taking to Your Lordship relevant paragraphs, Your Lordship. Page 5. My Lord. It is further submitted by the paragraph 2, Your Lordship. Bindu jahan laga hua hai.
Yes.
It is further submitted that learned counsel advocated that this appellant has appeared in the preliminary exam in the year Itna, thereafter in the main exam in the year, and thereafter appeared in the interview in the month of Itna, and after declaration of the final result, on Itna, this appellant has challenged the condition of the aptitude which is not permissible in the eyes of learned advocate has been clear upon this Itna. The further submitted that this appellant has carefully gone through the interview which was issued on Itna, caste certificate given from whereas the residence was not given as per the requirement. After cut-off, that is the correct residence was given at the time of interview on such and such. Thereafter, Your Lordship, it is further submitted by learned that whenever any cut-off date where there is bound to be few candidates who will fall on the wrong side of this cut-off date, but that does not mean
See, essentially, it is a case where
Your Lordship is correct.
there was absolutely blatant violation of the requirement of
My
advertisement.
Lord, in this case, my
In the
submission
sense
would
that
be, Your
even the
Lordship.
authority who had issued the caste certificate was not the same as per the provision of law or as provided in the advertisement. It was not timely filed also. So this is something absolutely against the
My Lord,
advertisement. itself.
my Lord, Your Lord, to some extent, Your Lordship, but my
And
argument would be
we do not read the judge. We read the judgment what it decides.
decides.
Not one observation here and there is not going to
My
actually
Lord, can
cut
you see Your
any
Lordship?
ice
Your Lordship,
in your
can we
favor.
see Your Lordship findings?
Yes.
Findings of the court. Regions, page 10, Your Lordship.
Page 10.
10. Regions at bottom. Having heard articles of both the side and looking to facts and whether we see no reason to enter this appellant, mainly for the following facts and reason for judicial pronouncement. The respondent have issued a public advertisement number such and next page, Your Lordship, which is properly known and the court combines civil services for several posts within the state of Jharkhand. This appellant has applied for the post of sub-divisional officer such and such. Then after, Your Lordship, looking for the condition number itna clause Roman 3, looking over which is at the next stage, one of the members it appears that those who were in search of this they had to apply along with their caste certificate which was mentioned unequivocally and unanimously. The residential certificate to be issued by an officer
You
not
just
below.
read the relevant portion. अगर पढ़ना शुरू करेंगे तो
चार
परसों हो
देखा
जाएगा.
जाए, this appellant has carefully gone through these conditions, along with the several certificates, caste certificate are given कर दी, and residential certificate given, which was issued by the circuit officer, district who is below the rank of sub-divisional. This certificate was given as on the date of filing of the form of the main signature. Thus, the cut-off date is not admitted residence was issued by the officer was not supplied on or before the said cut-off date. Next, Your Lordship, the appellant realized the error and presented the correct certificate. My lord, in this case also, Your Lordship, there is error in the format, Your Lordship, on the part of the appellant, and as such, Your Lordship, he deliberately did not mention, Your Lordship, about submission of the acceptance of the terms and conditions of the, Your Lordship, instruction and submission of the caste certificate before the authority, Your Lordship. Then, Your Lordship, next paragraph, I am only going through, Your Lordship, relevant paragraph, page 12, Your Lordship. This is, Your Lordship, about the cut-off dates, and thereafter, Your Lordship, thereafter, Your Lordship,
We have read it.
then, Your Lordship, kindly.
Anything else you want to cite?
My lord, few judgments, Your Lordship.
What all judgments?
My lord, then, Your Lordship, kindly turn to page 27 of the order.
Of the
Order, मतलब जो हम दिए हैं, उसमें बहुत सारा इशू है, उसमें बहुत सारा इशू.
27.
27 at bottom, Your Lordship.
Yes.
Here it is. It has been held by the Honorable Supreme Court case of Union of India versus Vinod Kumar as reported in such and such. It is also said that those candidates who had taken part in the selection process knowingly fully well the procedure laid down therein were not entitled to question the same. My lord, same provision is, Your Lordship, ratio is applicable because he was aware about, Your Lordship, and thereafter the several judgment on this issue has been quoted by the Honorable Division Bench, Your Lordship.
He is not challenging any terms of the advertisement.
My lord, he both, Your Lordship. If Your Lordship will go through the pleadings of the writ application, I am coming, Your Lordship, and the argument advanced on the behalf of the petitioner, both are contradictory, Your Lordship. In writ application, he is saying that even if it is issued, that is illegal. I will show, Your Lordship. Both issues are there, Your Lordship. Can we see his pleadings?
I've seen he has not disclosed about the filing of his
My
application.
lord, I am deeply
That I've
obliged.
seen you have shown it
I am
yesterday.
deeply obliged.
So there is a
And then-
suppression to that effect, but has he gained by that suppression?
My lord, he obtained the, Your Lordship, interim order by way of not placing the correct fact, Your Lordship. Meaning thereby he has not come before this court with clean hands. And as it, my lord, on instruction and इस पर हम पढ़े दे देते हैं उसके बाद. And my lord, केवल पेज 31 देख लिया जाए उसका
Of the judgment?
जी. इसको
31.
page 31.
Yes. Yes, tell us, what is it?
ये
226 का scope ना?
my lord, line number 9 from bottom, your lordship. Whatever leniency, your lordship has got it.
Yes.
Whatever leniency is to be given or whatever relaxation is to be given or whatever condition is to be waived for the reserved category candidate, comma, all can be done as a policy decision by the respondent and not by the court. Much less while exercising power under Article 2 to 6 of the Constitution of India, the court cannot be more charitable than the law, nor the court can be more lenient or generous beyond the policy of the respondent.
That's
Too much leniency will lead to chaotic situation any time and every time the candidates cannot be allowed to give the certificates. Then, your lordship, this is the findings, your lordship. My lord, when any stipulation is made in the advertisement or instructions, your lordship, that is to be followed. My lord, your lordship may compare it, your lordship. That same is, there is no difference. But that power cannot be exercised, your lordship, while exercising power under Article 226 of the Constitution of India, your lordship. And my lord, there is judgment of your lordship, Honorable Supreme Court 2020, Volume 19, SCC.
judgment, teacher.
My lord, I have prepared this compilation, your lordship, with Pawan Ura office.
Yes.
I have given your lordship.
It is there.
That is on the.
I have also preserved it.
My lord, my lord.
So Pavan Urao has become final.
No, my lord, that has not been, my lord, it was listed, but on that date, it was not heard, your lord. It was in bottom, your lord. My lord, kindly see.
That's right.
paragraph.
We are aware of 226. Don't worry about it. We will not exceed our jurisdiction.
My lord, kindly
That
see,
much I can
my
tell.
lord, only one line I may be allowed to read it out, your lord. I may be only allowed, your lordship. Para 6. Meter such and such for the applicant submitted the instruction given to the candidates taking examination for selection to the post of civil judge clearly bars the candidate from using a pen in any manner. The instruction given to the candidates are mandatory and cannot be relaxed. Such and such contained the initial stand taken by the respondent that he did not use the pencil which entitled her from the relief sought for. My lord, in this case also, your lordship, similar is the position, your lordship. He said that I am not aware about the instruction issued by the commission. And even if it is issued, your lordship, that is unconstitutional. Then, your lordship, she did not use the pencil, disentitled her from the relief sought for. No lenient view can be taken in case of violation of the mandatory instruction, as the order in favor of the respondent will be treated as a precedent. If the respondent is given a relief sought for, the other candidates who have been disqualified also will claim the same relief. My lord, in this case, your lordship, we have rejected several candidates who have not submitted the caste certificate in forma, your lordship. Then, your lordship, kindly take to para 8, your lordship. I am only taking, your lordship, the relevant para, your lordship. We have given our anxious consideration to the submission made by the learned senior counsel for the respondent. The instructions issued by the commissions are mandatory, having the force of law, and they have to be strictly complied with. A strict adherence to the terms and conditions of the instruction is of the paramount importance. The High Court, in exercise of power under Article 226 of the Constitution, cannot modify, relax the instruction issued by the commission. Or they your lordship, 8. My lord, the hard cases may make your lordship bad law. That has also been taken, your lordship. Para 11, your lordship. Para 11.
I will never pass a judgment which I cannot follow.
I am not on that, your lordship.
I do
am
not exercise power under 142.
My lord.
226, any judgment passed by me is certainly binding on me till it is set aside. So you don't worry about it.
My
I'm
lord,
very
30,
conscious
your
of
lordship.
this.
My lord,
An advocate can argue a case and on the next day he can argue it from the other side, saying that it has been wrongly decided. We will not do that. That's all.
my lord, only one few judgments, your lordship. My lord, Divya judgment I have cited, Your Lordship.
दिव्या, yes, one दीजिए सर दिव्या जी। जो साइड करना है दे दीजिए, मेमोरी में नहीं रहता है।
हाँ।
Yes, I remember.
2024
Here, this Gijoya case has been distinguished.
My Lord,
and
in this
facts have
case, Your
been
Lordship,
considered.
my Lord, I have cited, I have argued before Your Lordship.
And I followed also whatever
Your
you had
Lordship,
argued.
you have followed Your Lordship, and that has been challenged, Your Lordship.
Pending?
That has been challenged.
Pending?
Your Lordship. Pending consideration, Your Lordship. My Lord, in this case, Your Lordship, in this case, my Lord, the instruction was to submit a particular type of the certificate before the cut-off date. My Lord, she obtained after the cut-off date and on the
That's
on
right.
the
It is not a case.
It is
here.
not the case, Your Lordship. Then, Your Lordship, one more, Your Lordship. I will give other judgments also, Your Lordship.
No, that is enough. Yes, counsel for the petitioner has to say something.
My Lord,
Yes,
only
Madam,
one-
can I formulate
my Lord, kindly see, my Lord, the not coming before the court with clean hand, Your Lordship. Para 2 and 2010 volume 2 SCC, page number 114.
1-1?
My Lord, I am giving you. Para 2 and 24. I have marked.
Para 2.
Para 2 and 24. There are other judgments also, Your Lordship.
That's right.
My Lord, one judgment, Your Lordship, arising out of this honorable court, Your Lordship.
Which one?
My Lord, that I have taken from that is not reported as yet, Your Lordship. Your Lordship, that is, Your Lordship, from the Supreme Court, arising out of this honorable court, Your Lordship. He has filed a PIL before this honorable court without disclosing the fact, Your Lordship, that he earlier also filed the PIL on same set of the fact. He concealed the material fact, and on the basis due to the concealment of the material fact, the High Court entertained the application, Your Lordship. It was allowed, Your Lordship. When the matter went to the Honorable Supreme Court, the Honorable Supreme Court set aside the judgment passed by the Honorable Division Bench of this Honorable Court on the ground that concealment of the fact that briefing and similar application before the High Court was not mentioned by the petitioner, Your Lordship, and as such he has concealed the material fact, and as such the writ application is to be dismissed, Your Lordship. With cause, this is the judgment.
That amounts to fraud.
That amounts to fraud. That means, my Lord.
That you have not used.
My Lord.
I have improved your submission, right?
My Lord, certain words, Your Lordship, I can't.
That's all?
My Lord, one judgment, Your Lordship, I have poorly cited your. My Lord, one judgment, Your Lordship, I have also.
On what point? On what point?
My Lord, when certain conditions have been stipulated in the advertisement, and if the candidate has taken part, Your Lordship, and thereafter he is saying that this clause was wrong or that clause was wrong, that is not permissible, Your Lordship. That is, Your Lordship, can you have a look to para
That's right.
8?
He cannot, once he participates, he cannot challenge the terms of the condition.
But my Lord, now what he is contention in the original writ application.
That's right.
My Lord, his contention is this, Your Lordship, that even if that instructions have been issued, para 8 and 9, that instructions are issued, that is unconstitutional and that is not binding.
That's right.
On the guard, that in the original application there was no such stipulation. But he has concealed the material fact that I have submitted the caste certificate, I have complied the terms and instructions issued by the Commission, Your Lordship. He has not mentioned anything.
That's right. Judge.
Para 8 and 9.
8 and 9, no?
4.
That's all?
But there are several, I will give you about.
Yes.
Now, may I just formulate my points very briefly? But the first point which I am formulating is the status of a person belonging to scheduled caste and scheduled tribe depends on the caste which he belongs by birth and remains unchanged and static, and hence any condition prescribed in the advertisement for submission of caste certificate in a prescribed format is merely directory in nature.
Okay. Then?
Then my second proposition is that in a limited departmental examination, this distinguishes all the judgments which have been cited. In a limited departmental examination, prescription of the requirement of submission of caste certificate is contrary to the mandate of Section 73 of the Bihar Reorganization Act 2000. In alternative to what is the proposition number 2, in alternative, my submission is that a prescription of the condition of caste certificate in a limited departmental examination would always be treated as directory and not mandatory in view of Section 73 of the Reorganization Act. Then, my lord, the other proposition, a substantive right under Articles 341 and 342 conferred upon an SC or ST candidate cannot be whittled down on mere technicality of non-submission of caste certificate in requisite format.
Yes.
Now, these are the four proposals, and on the point of suppression, one that my contention is there is no suppression, which I will read the paragraph and so. And second, that the non-submission of the fact of submission of certificate has no material bearing to the ultimate result of the case in question, and it cannot non-suit me on that ground.
Do you have to say anything on format?
But my propositions are on format only, but the fourth proposition also which I gave, 341, 342, read with the format of the caste certificate.
This is
would be
basically referable to format?
Pardon, madam?
This is basically referable to format?
Yes, format, my lord. I am saying it will be adopting a technicality by saying that it
That's
cannot be given in a particular format.
Okay.
Now, Malod, state level, Malod, may I just before her ladyship, Malod, refer Malod one judgment in my compilation which I have given.
Mr. Garodia, we need to rise. We have
Yes, I know, Malod, that is 424 already.
Yes.
So, whenever your ladyship desires, Malod, day after tomorrow or tomorrow,
what all he has submitted and what all you have filed, right?
yes.
I need some time to go through it,
Yes.
right? Let
You
me
can
just
file
go
after
through it.
vacation, Malod.
I will post it after vacation. Prior to vacation, I do not want to reserve any further more judgment. That will be a burden.
Yes.
So,
And you are working on a vacation.
no, as it is, I have a number of judgments lined up. So, I just don't want to do that.
But then your lordship is not going to enjoy the summer vacation.
Summer vacation is not a vacation for us. It is a vacation for you.
No.
Summer vacation is homework vacation.
It appears your lordship.
Actually, this shouldn't happen.
This shouldn't happen.
You should your lordship enjoy.
Because a lot of readings are pending.
My lord.
Unless we read not only the judgments but also some jurisprudence, we don't actually improve ourselves.
My lord.
आप लोग से तो असिस्टेंस नहीं मिलता, खुद ही पढ़ पढ़ के समझते रहते हैं, क्या करेंगे? बताइए दूसरे हाई कोर्ट में कितना अच्छा अच्छा jurisprudence पे आर्गुमेंट होता है, यहाँ पे आप लोग बहस ही नहीं करते. हम लोग कितना आपके साथ मेहनत करेंगे बताइए. इसको ठीक से रखिएगा. And after we'll post it after summer vacation, and after the conclusion of argument, I want you to file a revised submission, because that is absolutely required. You have filed it, but it's an important issue. You have to file your revised submission. But I will just put this to the state. As to how, suppose there is a notification that you have to submit a caste certificate in a particular format. A person goes to the authority, files an application for issuance of a caste certificate. Whatever he has given, he has no option but to file that only, isn't it? His caste certificate, which has been subsequently submitted, is of the year 2011. By that time, that 2008 notification was already there. Then how do you explain it? Who will know? Who is not aware? Your officer?
No, my lord, he may have, your lordship, submitted the application for issuance of the caste certificate for educational purposes, your lordship, because it is prior to 2013, your lordship. My lord, then he petitioner is required to bring your record.
Because I've not seen that circular by which there is a different format for educational
My lord,
certificate,
there
and then
that-
you
my
just
lord,
file that you just provide me that that circular, that there was a different format for educational certificate for educational purpose and a different format for.
Previously, your lordship, there were two types of.
I'm aware that there are certain arguments, but I have never seen that circular. Nor I have come across such different formats in comparison with.
My lord, I will try to bring you.
If you are able to get it, you just.
Also, your lordship, the state can.
The arguments have remained inconclusive. Pose this case for further arguments on. We have to post it on a Friday.
Friday.
Because we do not know the constitution post vacation. We'll post it on a Friday only. July 12th.
Malod, I apologize today. I could not come. I was under the weather, Malod. Sorry.
No problem. Ye judgment.
For judgment from ready list item 2, WPS 129.
Let this matter be treated as parted. Have we made it parted earlier? No.
As your lordship.
क्योंकि बाद में फिर दिक्कत होता है.
As your lordship.
these writ petitions are dismissed. We have made some observation indicating that although we are not issuing any mandamus for regularization, etc., but this will not be a bar if they otherwise want to continue. Because till now they have continued, and so far Mr. Bholanath is concerned, I have said that he will be treated at par with others. Merely because he has not been given any extension, that does not mean that he will not be treated at par with others. This is the observation we have given. Otherwise, for I've declined. I've declined. It's a contractual appointment. Consciously a contractual appointment, continue from time to time. This is what my judgment is. It will be uploaded maybe by tomorrow or maybe by evening. Okay?
Minutes for number pair minutes. There's a matter in the daily list at serial number 6 minutes.
I know, I could not take
this
up.
matter being on after vacation.
All the matters will go after vacation only, unless they are fixed for prior to vacation. All these matters will go after vacation.
On your continuation part means solo regulation or regular appointment is not made.
I have not given any such observation. I have said that it is for the state to take a policy decision on this, whether they want to continue, not continue, whether they, because your communication has come that they need it, that is there. That is there on the. I have considered your IA also. Whatever allegations you have made, I have not taken one of those things into consideration while deciding this case, and therefore I have rejected that idea.
Only one part they have not disclosed that
I
part.
have taken care of. It's an elaborately. I have
The entire
discussed
post is a
it.
post or a direct recruit post.
I have discussed it.